And shifting to the other top story we're tracking very closely since this morning, the Supreme Court dismissing the plea challenging the appointment of lawyer Victoria Gowri as Madras High Court judge. A bench of Justices Sanjeev Khanna and B.R. Gowri were hearing the plea against the appointment of Gowri. The petitioner's counsel, senior advocate Raju Ramachandran, called for a stay in the matter by calling the case extraordinary. He argued that the material submitted to the apex court in connection with the plea shows a mindset which is not in tune with the constitution, adding that Gowri is unfit to take oath as a judge. Meanwhile, as the hearing was in progress, Victoria Gowri took oath as additional judge of Madras High Court. Joining us on the broadcast now is Justice S.N. Dhingra, former judge of the Delhi High Court. Very good evening to you, sir. Firstly, to understand from you your take on the Supreme Court's decision of dismissing that petition.
See, there was no way out for Supreme Court except to give this decision, because by that time this hearing had taken place, she was already sworn in. Once she was sworn in as judge of High Court, no way Supreme Court have struck down her appointment, more so when the collegium had itself recommended her appointment, and the only way out was impeachment proceeding. See, the only one other example where the Supreme Court had taken action against appointment of a judge was in 1992, when there was no collegium, and the person who was appointed, he was not even qualified to be a High Court judge. He was appointed by the executive. He was not qualified. He was appointed against the quota of district judge elevation. He had never held position of district judge, and the government had appointed him against the quota of district judges. He was neither an advocate nor a district judge. So the Supreme Court stepped into and held that his appointment was illegal. Here in this case, the person who was appointed as High Court judge, Gowri, she was selected by the Madras High Court. Her name was sent by Madras High Court to Supreme Court Collegium. Supreme Court Collegium cleared it, and she was given oath before Supreme Court took up this petition for hearing. So once she has become High Court judge, even if Supreme Court wanted to terminate her, Supreme Court could not have done it, because the only way out was impeachment. Once you become a judge and take oath of judge, there is no way you can be ousted from judgeship on any ground whatsoever except by impeachment.
Right, but do you also agree that it is a big setback to the lobby, the usual suspects who go on to take on such individuals, and in this case, as we've been speaking to very many from the judiciary who go on to say that someone's political leanings cannot be accounted for the very fact that
the lobby knew that once she was sworn in as judge, Supreme Court had no power. And you see, lobby also knew that she was selected by the same very collegium, 5 senior-most judges of the Supreme Court. And if the case had been handled by on judicial side by any of these 5 judges, naturally they would have been giving judgment against themselves. And the other judges who were not senior, they would not have taken up, because it was constitutionally barred. The purpose of lobby was different. One was to show somebody in bad light, to throw mud. Mudslinging is the purpose of this lobby, which they succeeded. And you see, now they can always challenge and question the decisions. They can always, say, look, we had already said so, that she is having this opinion. So we find her judgments in the same fashion, and this mudslinging can continue. But the purpose of lobby was do this mudslinging, in which they succeeded.
All right, Justice Dhingra sir, I
Yes.
want to thank you for speaking to Republic this evening.
Thank you.